Good afternoon, everyone, and welcome to our webinar. Just a few housekeeping tips or items before we get started today. The webinar is being recorded, and you'll receive a link by email to the recorded webinar. It will also be on TMLT's Resource Hub. The program has been designated for a maximum of 1 AMA PRA Category 1 CME credit. Physicians should claim only the credits commensurate with the extent of their participation in the activity. A copy of today's presentation and a fact sheet are available in the download pod on the far left-hand side. At any time, you may enter questions in the Q&A pod on the lower left-hand corner. I'd like to thank everyone for participating in the poll today. I think it's an interesting mix of how many of you are monitoring your social media for comments about your practice. I'm Kathy Bryant, and I will be joined today by Cassie Turner, and we'll be hosting the webinar. It is our pleasure to welcome you to responding to negative comments on social media can be costly. At this time, I'd like to introduce our speaker, Karen Zainer. Karen is an attorney and is a frequent speaker to physician groups on a variety of healthcare issues involving the medical profession. Karen is on the Advisory Council for the College of Liberal Arts at the University of Texas, Austin, a member of the College of the State Bar of Texas, and past president of the Texas Health Lawyers Association. She has developed numerous physician guides providing basic information to physicians on a variety of pertinent and practical realities of medicine and best practices today. Neither Karen or the planners of the program today have any financial relationship with ineligible companies to disclose pertinent to this presentation. At this time, I give you Karen Zainer. Karen, I think you're still on mute.
Oh.
Now you're good.
Can you hear me? Yes, you can
All
hear me?
good.
Okay.
Yes.
All right. Thanks so much for everyone joining. I think this webinar is going to be a fun one to give, and we've got objectives. So at the end of this webinar, I promise you that you should be able to do the following three things. Discuss why responding to social media posts could be a HIPAA impermissible use and disclosure, developing a social media response plan for your practice, and communicating how and when to respond to social media to others in your practice. All very important goals, and so let's get to it. I do appreciate TMLT letting me be here today for this webinar. I love my TMLT physicians and really appreciate the opportunity to help educate in these really difficult areas. I mean, they don't teach this stuff in medical school, and so let's get to it. Okay, so I've divided this into three parts. The first part is a Hipaa refresher, and that's because the main topic in part two, which is really why we're here today, really does have a basis in the Hipaa rules and regulations, and every state really takes HIPAA rules and regulations and makes it part of their own state law. So really this is important to make sure that you and your practice are complying with not only the federal law of HIPAA, but also the various state laws, including Texas, that are really important to make sure that you're complying with. And part two is going to really drill down on the social media topic that you signed up for, what to do with those negative reviews, how to react to them. And then part three if we have time, because we may have questions regarding part 2 that take up more time, but if we do have time, then I'm going to add some bonus tips relating to, again, HIPAA and the state and federal privacy requirements under HIPAA. So first, part 1 is a Hipaa refresher. I know that the physicians on this webinar, as well as your practices, have HIPAA training specific to not only your practice, but when you go to hospitals, you also get the training specific to those hospitals, and that's really, really important. But taking just a bit of a higher level to make sure that we understand some of the definitions. Obviously, the training specific to your practice in a hospital are really going to focus on specific passwords, specific systems, all very important to make sure you're complying with HIPAA. I want to make sure that we're all understanding sort of these definitions that help us understand how to comply with HIPAA. So the first one would be what is PHI? PHI is the acronym that's really important in HIPAA, protected health information for each patient, and when something is PHI, you as a physician and you in your practice need to make sure and protect that. And so we'll talk about that. We'll also talk about who is a covered entity. Let me give you a hint, probably you and your practice. So, but we'll talk about that. And then also importantly, what is a PHI breach? What is a breach of protected health information? And because it's only when you recognize what can be a breach that you're able to guard against it. Okay, so first, what is protected health information? So HIPAA is a federal law on patient privacy that must be complied with at all times. And like I said, states also adopt HIPAA standards and have laws that actually work with HIPAA and on the federal level, and the state laws work as well in order to guard against impermissible disclosures of HIPAA. And so we're really talking about federal and state laws, including in Texas. PHI, again, is an acronym. It's called Protected Health Information under HIPAA. And so the definition of PHI is all individually identifiable health information for a patient held or transmitted by a covered entity in any form or media. And that's whether it's electronic or paper or even oral discussions on the phone or between providers or with the patient. The rule of thumb that I like to tell physicians is to make sure that if it contains any type of health data, including payment information, and it identifies the individual, then assume it is PHI. And you always want to over-include in order to make sure that you're not conveying any information that shouldn't be conveyed or has a chance of being PHI, because it might be, and you've got to protect it. So this is true even if the PHI itself is redacted. So even if the name, the social security number, the date of birth, the address, the medical record number, even if those things are redacted, a covered entity, a physician or your office, still must be careful with it and protect it. Okay, next, who is a covered entity? So HIPAA only affects covered entities and, in parentheses, and their business associates, which is, that's sort of another topic on what's covered under HIPAA. A business associate, just to be clear and to be concise about it, a business associate is somebody who helps a covered entity and needs to get PHI in order to do so. And so the example that I typically use is a lawyer is that person. So if a physician, a covered entity or practice is hiring a lawyer and conveying PHI to it in order for the lawyer to help them, then they're going to be a business associate and they're going to have to comply with HIPAA and have what's called a business associates agreement. So just on the side, remember, if you're a covered entity and you're sending that PHI out to someone, you've got to make sure and have a business associate agreement with that entity, like a lawyer, in place, and make sure that that lawyer or other third party is complying with HIPAA just like you're complying with HIPAA. So, so that's an important point to note. Okay, so what is a covered entity? Health plans, healthcare clearinghouses, healthcare providers, so including physicians, who conduct certain financial and administrative transactions electronically. So, for example, claim submission, billing, and fund transfers. Now, HIPAA is a very complicated and lengthy law, and so this definition here is sort of basic, but it has a lot of pieces to it, and so I would advise you that generally it includes healthcare providers, including physicians, doing transactions electronically, and I believe it's prudent for any actively practicing physician to assume that they have covered entity status. In other words, unless you have a solid legal opinion specific to your situation saying that you are not a covered entity, then you need to assume that you are and comply with HIPAA. And then just as a side note, when it comes to HIPAA, an employee of a physician or a physician practice is also part of the covered entity, so there's no need for a business associates agreement like the example I was giving you before. Business associates agreements are needed in the cases of independent contractors or relationships like lawyers or accountants, but if the employee is employed with a physician practice, then that employee is a part of the covered entity and needs training and needs to comply with HIPAA, but doesn't need a separate business associates agreement or contractual agreement in order to include them. And as an employee of a physician, that employee is a covered entity as long as they are acting in the course and scope of their employment. Okay, so moving on, what is a PHI breach? Okay, and that's a defined term in the statute. And again, HIPAA is a long statute, so I'm sort of making these definitions very concise, and their details are obviously in the statute, but I think you want to look at what a PHI breach is by knowing it's any impermissible disclosure of PHI unless low probability that PHI was disclosed. What is low probability? That's in the statute. There's a lot of different angles and questions related to whether or not there's a low probability that PHI was disclosed. But for purposes of this discussion, I want to just bring some examples that might affect the physicians and their offices so that they can be aware of those. So some of the ones that I've come across are things like forwarding emails outside of hospital healthcare entities or practice entities to addresses like personal accounts. That always is a big problem, and so that's that screams out PHI breach. So being aware of that's important. Stolen or lost mobile devices, really important. Laptops, phones, those sorts of things. Accessing and viewing PHI if a patient is not yours. Remember an electronic trail remains, and so that's always one of those ones that you're looking at a red flag. And then the one that we're here to talk about today, disclosing PHI on social media, even if it's redacted. And so the important thing to remember about this topic that we're going to get into the details of is that disclosing PHI on social media, even if it's redacted, that breach of PHI can happen even with, especially if it's with your own patient. The other ones that we're talking about, it may not be your patients, right? You're still, if you have access to the information, you still need to make sure and be aware of it. But this is one where it's your patient, and you need to be aware that there's a chance that you might breach HIPAA by disclosing PHI on social media channels or to third parties, even if it's redacted. And so we really need to be aware of that. And we'll talk about it in part 2. Okay, again, being aware that PHI is really everywhere. We've got an incredibly broad definition of PHI. It includes many common identifiers, so things name, address, birth date, social security number, very common things. But they are PHI if they can be associated with health data content that you receive as a covered entity. So just a quick example, you've got a phone book, right? The phone book is not HIPAA protected, it's not PHI, But when you combine the information in the phone book, name, address, birth date, phone number, and you combine that with your knowledge of a patient's health data content in your capacity as a covered entity, then that's turned into PHI. So something as simple as revealing that the person in the phone book is a patient of yours is actually PHI. And so I think people are surprised by that. But the knowledge that you're their patient alone can be a Hipaa breach. Okay, so again, PHI is everywhere, and that's usually the case in the healthcare environment, so we just have to get used to it and be careful with it. Okay, and avoiding PHI breach risks for all patients. Really important as we close out this part one, making sure that we're all aware that healthcare environments, physically and virtually, pose various warnings for PHI breach. And so being aware of risks posed and avoiding them is really important. So again, back to some examples. Patients that are not yours, or you're not treating them. And if you're exposed to their PHI, that could be a Hipaa breach. Physical presence in a healthcare facility where you do not have clinical privileges. Again, if you come into the information PHI, when you don't have privileges at that facility, then that is a PHI breach. But again, back to the topic that we're focused on today, there are situations with your own patients that can violate Hipaa, and so let's make sure and guard against those as well. Okay, so part two. So today's topic: responding to negative comments on social media can be costly. So I'm giving you a website here. This is the AMA's. It's like a column that deals with various topics, sort of this idea of how to help physicians understand and educate themselves about various issues. And so this is actually one of them. So I've given you the website there. Feel free to look at it. And this talk, parts of it have been taken from the AMA's guidance when it comes to these sort of issues. Okay. I can't believe a patient posted that. I mean, seriously. So number one, look at your social media. Google yourself. Google your practice. Have somebody at your office be in charge of understanding what your public profile looks like, what your Google reviews look like, what people are saying about you. I mean, we all know, we all need to Google ourselves. And even, as a lawyer, I do it. And I always, before I do it, there's always sort of like, ooh, what's going to be there? So you got to get over that and just do it. So making sure that you're really aware of what is being said about you is really, really important. And so what happens when you do that and then you get I can't believe that patient posted that, okay? What should you do if a patient posts a negative review, a false review, an inflammatory review, a review that doesn't make any sense? I mean, what do you do? Okay, so HIPAA and other privacy laws, like state patient privacy laws, do not prohibit you from responding to patient online reviews. You can do that, okay? But unlike other businesses that can respond just to however they see fit, respond to the substance of whatever was said about whatever experience or transaction happened, HIPAA and state law patient privacy protections limit what you as a covered entity and your practice can say in response to a patient review in a public forum or to even any other third parties. Okay, that's really important to understand. It seems so unfair. It seems so counterintuitive. I mean, believe me, I totally agree. It really does. Physicians must maintain the privacy of the patient's PHI even if the patient has revealed their own personal information in the review, okay? A patient is free to share any information about their own health. It's their stuff, right? They can take their PHI and post it on the billboard, print it in the newspaper, put it in the online forum, say exactly what their side of the story is with respect to their last office visit. And physicians in their offices are still prohibited from disclosing any patient-specific information, anything, even the fact that that actually is their patient, even in their own defense. Not fair, seems really counterintuitive, but that is just the way it is, okay? Now, this is also true when a physician contacts a third-party website directly. There's rules, there's, community standards, there's rules of the game as to how to, be good on whatever platform or environment. And so even when you go to a third party who runs the site and say, listen, I need this taken down, and you're following whatever dispute processes, the physician still has to comply with HIPAA and cannot disclose that information. So how does a physician dispute false and inflammatory reviews of their patients, in this forum and get it taken down? That's a good question, but I know what you can't do, which is you can't disclose PHI to that third party. You can't do it without the specific explicit authorization of the patient. Okay, so I don't know if anybody has looked at my website. I hope you will. I'm here to help. What I do is to help physicians, and we'll get some information at the end of the program that will give you my website. But if you look at my website, especially under the publication tabs, I've got lots of articles. I also have physician guides, and I typically do the setup I usually have is sort of this top 10 tips, which is, again, it's all this stuff is written for physicians. They are not law review articles. They will not take very long for any physician or anybody in anybody's physician office to review their tips in order to help in different topics. I've got one for HIPAA, one for credentialing, one for social media, one for data bank, one for Texas Medical Board complaints. There's a variety of top 10 tips, again, on my website. And so in your spare time, which I know you don't have any, but in your spare time, I do think it's helpful to educate yourself about the various things in healthcare, in the practice of medicine that may come up. But so in that spirit, I also created my top 10 tips when negative reviews are posted, especially for this webinar. And so we'll go through them now. And I think number one is probably, one of the more important ones. Is to never respond immediately. You just cannot respond immediately when you see a review. Okay, you take a deep breath. Even walk away before you respond in anger, because responding in anger is a problem, and it's going to be a problem for you. After when things could happen. It's a public forum when you respond typically. Even when it's not a public forum, it's on a private channel, or like I said, if it's a dispute with a third party, it's a dispute on a third party website, and you're disclosing that information, the risk that that violation is going to come out is a problem for you. So you want to make sure that you're doing all you can to respond when you're more able to determine what you need to respond, how you need to respond, and to deal with the issue. So number one is very important. Do not respond in anger. Number two, never acknowledge online or to a third-party website that the person is actually a patient, or disclose any other specific patient information. Again, a physician cannot disclose information about the patient without the patient's explicit permission. This is so important. Do not forget this. And again, and this seems, really just unfair, the patient's own disclosure in the review, even of the specific details of the patient, event or encounter, does not give a covered entity permission to disclose information in defense. There's just no waiver argument that the patient has. You can't make that argument. They waived, they put it on there, they waived. It doesn't work with HIPAA. Okay, tip number three, if you do respond, keep it very general and professional and respectful. And I say if. I mean, you probably do want to respond in some way just to make sure that people who are looking at the reviews realize that you're attending to these issues and you're trying to help even dissatisfied patients, trying to figure out how to help them best and give them the best medical care that they can have. So so when you respond, making sure that it's very respectful, general, and professional. So an example you can use whatever language you want, but an example is, we are sorry to hear of your experience. Please contact our office directly so that we may specifically address your complaint. And then if they do that, then contact them and help them figure out how to resolve the complaint if you can. Okay, number 4, this one was in the AMA tips, and so I'm a little guarded about it, but if you respond with medical information, be sure it only involves general policies and standard protocols. So I do think it's important to realize that you can't respond with specific medical information, especially about their condition. But the AMA tips that I pointed you to actually say, well, if you're going to do something, do general policies and protocols. So an example that they use is a response could be office policy and standard medical practice is to determine if a patient has a viral or bacterial infection, and only to prescribe antibiotics when there is a bacterial infection. So that's very broad, very standard. Now, does it sort of, give information, implicit information as to what the patient was there for, or the fact that the patient is a patient of yours? I would argue maybe it does, right? So I would be careful with number 4. And certainly if you're going to respond with any medical information, then you want to not make it specific and make it general. Okay, tip number 5, consider responding offline directly to the patient, again, respectfully and professionally. A patient might even remove or amend the negative review after the physician or practice reaches out personally to them. So you never know. Okay, number 6, remember that your online reputation is not destroyed with one bad review. So usually patients look at the physician's overall rating, and the bad review may not be taken that seriously, especially if it's really, if it uses hyperbole, if it's really emotional, if it's really, sort of out there, that may not be taken seriously, especially in the midst of good reviews. Okay, tip number 7. As part of this process, taking note of the criticism, looking at it objectively, maybe even from the patient's point of view, and deciding whether or not your office or you could have done something differently. I mean, we can all use sort of feedback and trying to figure out, especially with the experiences that don't go like we want them to see if you can improve. Number 8, making sure that you train yourself and your staff on HIPAA and developing policies and procedures related to the appropriate disclosures of PHI, especially on social media. So trying to figure out how you will respond in a way that doesn't violate HIPAA, but actually takes into consideration the complaint and tries to solve it and does it in a professional and respectful way. Because again, if you're doing it, in the public forum like social media, then other people are going to be looking on to that. Also, trying to figure out how you're going to respond to issues when you're disputing them with, for example, third-party websites pursuant to their policies. Just making sure that you have a person who's going to help with that in your office, and that person is aware that with the restrictions or limitations as to what they can do, and that you're always approving that as a physician. You're always approving that to make sure it doesn't violate HIPAA. Okay, tip number 9, make the process of online reviews available to your patients and to complete, because most are happy to complete and will usually post a positive review. I mean, they're coming back to you year after year after year, and they love you, and so make it easy for them to complete the reviews. And so maybe that takes, again, somebody from your office who's really focused on that area, and then making sure that you're involved in that process. Because again, you as the physician, you've got to make sure that it's all HIPAA compliant, and so even though you might have resources that help you, you're at the end of the day, you're just like you're captain of the ship when it comes to your patients, you're captain of the ship when it comes to your office and their protocols. And then number 10, just making a continuing effort to review and update your practice website and online profile. I mean, this is what patients see, this is what the public sees, so it's worth it, time, effort, investment-wise, to do that. Now, whether or not you go to another source, like a company who focuses on that, that's important to do, and that's certainly, to me, if you get the right one, worth the investment, but also remembering that those companies may not know HIPAA. And so you need to make sure that you're doing things and complying with these HIPAA rules and regulations, whether the company really does know and works only for physician practices or hospitals and really, knows what to do and what not to do, or if your company doesn't really know it, you need to make sure that you're aware of what's happening and you're making sure that, nothing impermissible is being disclosed. Okay, so I'm to part 3. I don't know if we have any questions at this point before we go on to part 3 with the bonus HIPAA topics. Do we have any questions?
Yeah, Karen, there are a few questions.
Okay.
One was asking for you to clarify a little bit about the presence at a healthcare facility where I do not have privileges as a PHI breach. That one
I will, let me just say what I was meaning by that, okay? If you're at a healthcare facility and you're a patient, but you're also a doctor, then you're not a covered entity, right, because you're there as a patient, okay? So then don't worry about it. But if you're there as a doctor and you're moving forward to see things, presuming that you have the ability to do so, then think twice about it. Now, rules and regulations of hospitals, whatever entity you're in, they have rules and regulations, and they may detail, if you don't have privileges, but you want to move forward to try and get, I don't know, temporary or emergency privileges, then you've got to follow those rules and regulations. What I've seen in the past is some physicians being in there. One case in particular was, somebody visiting, a girlfriend or a boyfriend, right, and thinking because I'm a doctor I can come on in, and that's not a problem. And I will tell you that that could be a problem. So just remembering where you are as a covered entity, where you have privileges, and making sure that you're only accessing where you're supposed to be accessing is really, really important, especially because you may walk by and see a chart when you're physically at a different location, right? And so I guess, who's going to record that? Although more and more we see video cameras, frankly, but you're not in the medical record, so maybe nobody knows that electronic trail because it's not there. But at the same time, you need to be aware that you're not supposed to be in the facility, and even that can be a problem for you. So, I was just really kind of referring to that generally as, breaches that might happen, for covered entities, and to be aware of that. Again, we're drilling down into the one topic about social media really in this presentation, but generally, if you're a physician and you're there as something other than a patient, right, and you don't have privileges there, then you really need to be thinking about whether or not you need to be in that environment. I hope that answers the question. So.
Great, thanks. Another question, Karen, is about whenever the review is not a patient or of the clinic, how would you recommend handling that? And also, if they were to report it for some reason, let's say to Google, as not a true patient, would that be a potential violation?
Okay, so we're talking about, good question, we're talking about a review or something in, that's being on a platform from a person who is not a patient, correct? So if it's not a patient, then you're not moving forward as a covered entity, and covered entities are and their business associates are the ones that are you only get in trouble if you're a covered entity or a business associate or somebody in that chain. And if you're not, then you're not, and HIPAA doesn't apply. And again, everything's specific to the state, patient privacy laws and the state laws that kind of bootstrap HIPAA. But again, that's typically conditioned on the person whose information might be shared being a patient, and the doctor or the doctor's office being a covered entity. So I would say, you can respond however you want, just like any other business. But I would make sure that it's not a patient. And then the other thing I would say, and just thinking about this question, if you might get the patient's relative who's saying it. And so that's a person who may have special status related to the patient. And again, it's going to be about the patient typically, right? And so again, it's the information, even if the patient's mother gets on there and does a review, when you're responding to the patient's mother, who's probably saying something like, you're a doctor for my daughter and here's how you really screwed up, right? You're still going to be talking about and revealing the information about the patient. So I think you need to be real careful if you have anybody who's either the patient themselves or speaking on behalf of the patient, either caretaker, relative, decision maker, whoever that may be. You still need to be careful and probably respond in compliance with these tips, even though they're not technically a patient.
Perfect. That actually answered quite a few follow-up questions that came in as well. Another question is about tip number 3, just in a general response, just clarifying that does not mean you are acknowledging that they are a patient, or does that acknowledge, in fact, that they are a patient based on your tip number 3 for a general response?
I'm so glad you guys are paying attention. Yes, that is a really good question, and there's no magic words in that quote on tip number 3. I'm trying to remember what it is. I don't even have it, but it was a very general. Can we go back to it? Let's see. Oh, I can. All right, there we go.
Tip number 3 is, if you respond, keep it very general, professional, and respectful. We are sorry to hear of your experience. Please contact our office directly so that we may specifically address your complaint.
So I kind of wrote that. There's no magic words to it, but really the gist of it is focusing on, we are sorry to hear of your experience. The experience that we're talking about is the one that they mention on their complaint. Okay, so we're sorry to hear of your experience. Please contact our office directly so that we may specifically address your complaint. I don't think that acknowledges that they're a patient. It just says, we're sorry to hear that you're upset. So whether this is actually a real patient or somebody who came in and delivered flowers, right? Or came in off the street to get a cup of water. I mean, it doesn't say they're a patient. And so, I'm okay with it. I think it's okay given my, again, look at the AMA, that website, because, they're giving helpful hints as well. I think that passes muster to me, and also, tells them, please, let's talk about this. So I like it. I think that you're probably okay if you say something like this. Anything more, I think is tough, because it may disclose that they're an actual patient, or may disclose other details of whatever happened in the office that you might know about as a covered entity. So I would keep it very general.
Great. Thank you. A couple of questions about posting, Karen, on social media platforms. One, should there be a response on those platforms? Should there be consent? And what, as another follow-up to that someone asked, is if there is urgent or non-urgent medical questions on Facebook Messenger, should there be a response to those types of posts?
Let me take the latter one first. Yeah, if there's anything urgent, okay, that you're aware of, then yes, I mean, responding to that in a way, and you should have patient portals or other ways to directly contact the patient. So, phone numbers, or, however it is that you usually respond to the patient that's not in, the public venue, the social media channel, is probably a good way to do it. But yeah, I mean, real good issues brought up with this question. I mean, if this is, on a Facebook post, it's a Facebook, account through your practice, then because you have that, I mean, I think you've sort of put it out there that you're receiving information. And so ignoring the information is probably not a good thing to do. But again, channel it back through your regular practice, whether it's a patient portal or calling the patient to respond to it. Just like if the patient would call or fax something directly saying, here's my issue, attend to it. But I wouldn't necessarily do it through the public Facebook response, even if it's a private group, unless it's absolutely private account. And again, if you got a patient portal, that's a really private account, right? I would just opt to do it, that way as well, to make sure that you're keeping the discussions very, confidential. Okay, and then the first question I'm trying to remember, the posting consent.
Yeah, a follow-up to that, Karen. Yeah, just on that poor question, I'm sorry to interrupt you. If they're reaching out to the personal physician's account versus an account that's linked to the practice, for follow-up on that one, is
Okay.
what they were asking for, a little bit more
Absolutely.
information.
So when I talk to physicians about boundaries, and we talk about social media and Facebook accounts, I mean, it is really difficult for personal Facebook connection to have patients on there. Now, you're going to have friends, and they may come back and ask you questions as a doctor, right? Again, you're going to want to funnel them through your professional channels, because if you encourage people coming to your personal Facebook page and asking and answering those questions, and I do really think that blurs the lines that we don't want to blur. So I would anything like that, I would make sure that you're reminding them to go through the channels of your practice as opposed to your personal account. But it's it's a sticky issue. How do you be a friend? Can somebody friend you? And are you able to maintain those personal relationships? If patients are friending you on your personal account, I think you want to kind of step back and remind them and channel them to your professional account.
Perfect. The original question on that, Karen, was about consent before responding on these social media platforms and direct messaging.
I guess you could draft a consent that says, patient agrees that I can post anything that I want as a covered entity, including HIPAA protected information on this, on social media pages. I think it's really difficult to, you have the patient's consent, but do they really know what that means? I mean, is that a consent that is really going to hold? I say, even if you get that consent, I mean, why would you want that consent? Okay, specific consents may be drafted with respect to specific situations, but when it comes to just being able to respond, on social media accounts, I'm not sure that would be something that I would recommend. I think the best things to do for physicians is to get consent when you need it, because you do have your regular HIPAA consent for your office for use. But if you're going to sneak in there, all social media, I think you're sort of setting yourself up for a patient complaint. It's not really very fair. And so, I think situations, specific situations you may need specific consents for specific things, but when it comes to, hey, let me just get a consent for responding however I want to as a covered entity on my website or on a social media platform, I don't think that's, I think it's better to just make sure that you're keeping this information as confidential as possible and responding in general ways, and then again looping it back through your practice channels. That's just my opinion. But if you do, let me say that if you are relying on the consent, right? And I don't know if it's for television or for books or for whatever sort of use. I mean, if you are relying on the consent for patients, make sure that you're getting a lawyer to look at it to make sure that it has what it needs in order to do that, because it's going to be looked at. It's going to be scrutinized. So making sure that you're not just taking a form consent, off the internet and having the patient sign it. It's really important to make sure that if you're going to do this for the reasons that you really need to, you're getting that consent drafted specifically by a lawyer who helps physicians.
Great. One question that related to the section 1, Karen, was about handoffs between shifts of doctors is handled via text messages. So they are not including any identifiers of sex or age, basically a text message that starts as new patient consult, then lists diagnosis, plan, what to look for, etc. Text is not encrypted. Could this be a potential breach or HIPAA violation?
texting is tough. I mean, you all got different phones, providers, the security. Yeah, it would be one thing if you were texting, say you were at a big, practice or a big healthcare, facility system that had, that facility gave phones out to everybody and their provider encrypted it, right? And that it was all sort of within a system and the closed loop, okay? And in that case, and again, you'd have to look at the specifics of it, but in that case, assuming it was all really HIPAA protected appropriately, then those texts would be fine. It'd be closed loop, kind of like, I guess, closed loop email or iMessages or whatever. But I don't think that's what we're talking about. I mean, what we're talking about are, physicians who have, and providers who have phones, okay? We don't know the security with respect to each of those phones, and we're really just texting. And so when you're talking about the information, and again, you said, there's no name, there's no, social security number, there's no, address or birth date or whatever, even when you take out those things, the diagnosis, I mean, you're giving information about the patient for purposes of having the new provider understand what the patient's condition is. And so the details, again, back to the definition of PHI. What is PHI? Well, it's anything that allows a third party to reasonably identify who that is. And so if you're talking about, a patient, at this hospital and you get to the details of their care, well, at some point, there's going to be enough information to reasonably identify them. So, it doesn't surprise me. I mean, I know, that sort of thing is going on. The question is whether or not there's either a possible or a real HIPAA violation, and I certainly think there's a possible one. And so it's, will anybody, actually get caught with respect to that? Well, maybe not, but, HIPAA's serious, and it's got criminal and civil penalties, and you never know when that sort of thing gets to somebody's attention. And so as a lawyer, I'm telling you that I'm not convinced that that's permissible under HIPAA.
Okay, Karen, I think that wraps up most of the questions from this section. If you wanted to do the bonus section that you had.
All right. We'll do it real quick because I have, what time is it? I have, so do I have 10 minutes or?
Yep, we have time.
We'll do it sooner than 10 minutes. We'll breeze through this. Okay, so part 3, and thank you for all those questions. I mean, I really, this is hard stuff. I mean, this is stuff that there's, the answers are difficult. And so, so I appreciate everybody asking the questions. And again, I'm here, my practice, I'm here for physicians. And so, if you think of something afterwards, contact me. Please let me know because I am here to help. This is tough. This is tough stuff, and you guys and gals need to know this stuff and make good decisions. Okay, so part 3, we've got some bonus ones. I just always I love to be able to put these kind of topics in front of physicians because these are topics that probably come up, and you need to kind of know generally how you can approach them. So the 3 that I've chosen here, one is audio-video recording, one is appropriate locks and safeguards, and then the last one is mobile devices pose special risk. And so let's go to the first one. Okay, so a lot of times physicians will ask me, well, I want to record surreptitiously a certain conversation, and so should I do? Is there a problem with me doing this? And so so to me the question really, the important thing that you have to know is if you're a party to it is the important distinction. So really the question is, should you record a conversation over the phone or in person if you are a party to it? And so first question is it legal? Because you certainly don't want to do anything illegal. So again, back to the party who's participating distinction. So it's really important to check state law. And then of course if you're talking about, it's one thing if you're recording in person or you want to record in person. But if you're over the phone, then you may not even know, what law applies because you may not even know who all the participants are on the line, what states they're in. So, but basically, is it legal? you have to check state law. And so Texas, for example, is a one-party state. So what that means is that if you're a participant in the conversation, then generally it's not illegal to record either in person or on the phone. Now, if you're not a party to the conversation, then that's what we call wiretapping. Or, I don't know what we call it when we're a potted plant in a room with a recorder, but, that's something you want to stay away from because, that is illegal. But if you're a party to it, Texas is a one-party state, and so that's not necessarily illegal, but it might not be the best decision. Other states have what's called two-party laws, and so they require some form of consent of the other party. So again, you'd want to check your state law and make sure you understand if it's a one-party state like Texas, understanding that, or if it's a two-party state. And again, beware of phone conversations or even Zoom, webinars or those kind of audio conversations where you might be in another state and not even realize it, or have to understand what the law of the state for each person who's participating in the conversation. But even if it's not illegal, like in Texas is again a one-party state, you're participating in the conversation. The risk may outweigh the benefit, and so for me, in my experience, and it's just anecdotal because I'm a lawyer in a small firm, and so I just come across cases as I come across them, but I really haven't ever seen a case where it's really helped the situation to have a recording, video or audio of what's happened, especially in a healthcare environment. In fact, if I have seen some effect it's had on it, it's been that it actually makes the issues worse, causes a concern in the healthcare environment. Because you may, because it's a healthcare environment, you may have PHI around, okay? Even if you don't, if it's, for example, like a peer review environment, there's policies and procedures that say that the stuff is confidential. And so doctors, and I've had this happen, doctors who have issues with peer review, and then the hospital or healthcare entity finds out that they've actually made recordings, that actually adds to it not only the peer review issues that whatever that we may have, but also an additional allegation of HIPAA violation. Or a violation of the medical staff bylaws as it relates to confidentiality of peer review and other materials. And so I don't typically see it really result in anything that's that helpful. And in fact, what I typically advise a client to do, for example, who's going into a peer review meeting and wants to make sure and kind of feels cornered and wants to make sure that they're getting some proof of what's said. Typically what I tell that doctor to do is just after you're done with the meeting, go to a place that's private and then just write down everything that's happened in detail so that you'll remember it, because you're a witness to it. And so that may be not a perfect solution, but at the same time, to me, it's a better solution than putting yourself out there with risk when you're recording something. Okay, so to the next topic, using appropriate locks and safeguards. And again, we're kind of coming back to the HIPAA and the patient privacy trying to do the best you can for best practices. And so just remember, whether it's the information, the PHI is either in electronic form or in actual hard copy of it, then it's best to, I put here, leave it at the office. It's best to kind of leave it in the place where it's kept. So whether it's the office or whether it's the healthcare facility, a lot of times it's best to leave it there and not do things like take it home. There's specific and detailed requirements that govern PHI and the security you have, including locks and safeguards. And so, giving an example, hard copies locked in a file cabinet or a desk drawer in a locked office, probably meet the standards in HIPAA for security. And so you want to keep it in there. You want to keep it on the premises of whatever entity, employer, healthcare entity. Once you start taking it away from there, and then again, this is sort of talking about a physical form. You take it home and you put it on your kitchen table. Well, I mean, that's probably not the best environment to have it in. Or you take it to Starbucks and you leave it on the chair. That's a real problem. Okay, so just keeping in mind that locking the information up and keeping it safeguarded, whether it's in the physical form or whether it's in the electronic form. Again, it's a little bit more complicated with the electronic form, protecting it, keeping it, making sure that you're not, if it's on a jump drive, making sure that it's not left on the table at Starbucks, or making sure that, even at home, there's a risk to it. Now, so just remembering that your home environments are places where that might not be HIPAA compliant. Your employer or your office practice may say, here's how you work at home, and here's how, here's what's acceptable to do. And so, if those, details and protocols are being complied with in a way that's HIPAA compliant, then you may be able to work from home. But just remember that, you make sure to have the appropriate protocols and follow that as it relates to whatever employer might be involved or health care environment, and just assuming you can take things home from those environments and still have it comply with HIPAA is, that may not be a correct assumption. It's really important when we get to, we've already talked about the hard copy, but you get to the electronic form, the real concern is always the unencrypted electronic protected health information. You got to safeguard that. So especially, the biggest violator is emails. To send emails to, we talked about before, your own personal address or any third party, when they're unencrypted is a problem. And so if you ever find yourself doing that, including to an attorney that you've hired, right, or you're just talking to, do not do that. Make sure that you're not sending that information, and even when you do send it to an appropriate lawyer who you've hired and you're a business associate, making sure that you're not sending it in unencrypted form, because unencrypted means it's out there and could be picked up or accessed by people who don't have authority to access it. So just remember, when you're sending this, if you're sending something and you're thinking, maybe I shouldn't do this, then call somebody to make sure that you're not doing something like violating HIPAA. It happens all over, but you just don't want to be the person who's doing it, and then there's a problem with it. Again, HIPAA policies and procedures must be followed at all times. I'm sure in all your offices you have very specific HIPAA compliance policies and procedures, so remembering to continue to train, understand, and know what those are and comply with them, and making sure that your office does the same is, could not be more important. All right, then finally, our final bonus topic is the mobile devices pose special risk slide. I actually have, and I think it's in the next slide, and then the materials that are attached or available for this webinar. But this is sort of the Health and Human Services, which is the federal agency that enforces HIPAA. But they have a nice sheet full of tips. I'm giving you the website to download it, and you have it here as well. But these are sort of just the simple tips for the mobile devices. Everybody has mobile devices, laptops, iPads, phones. And so really understanding how you're going to protect it through your mobile devices is really important. I've just taken a few of the tips. There's more on the sheet, but I'm just going to tell you, sort of my few favorites. But again, a good read and availability of the sheet that really goes through a lot more tips. Just to remind yourself of best practices as it relates to mobile devices. So number one, it's best to not have any PHI on your personal phone, your laptop, or other mobile devices. I mean, if you don't have PHI on your phone, then you don't have to worry about, whether or not, if you lose it, it's a HIPAA violation. You don't have to worry about whether it has a password. Now, I'd have a password on my phone anyway, just because it's, if your phone has private sensitive information, but if it doesn't have PHI on it, then that's that's a good thing, because what you don't want to have is have an issue with a lost phone or a stolen phone, even if you have the issues of you've done the right things with respect to password and that sort of thing. Not having that issue is a good issue to not have. But some of us, many of us, have to have these things on their devices, and so if for any mobile devices that contain PHI, making sure that you're strictly observing the protocol. So again, I'll give you that sheet that we're talking about. It's got that lovely lady with a white coat, and and she's lovely, and she's telling you all the wonderful tips of mobile devices per Health and Human Services. So making sure that you have that available and you're reviewing that with your staff and yourself to make sure you're using best practices. So one of the most important ones is just maintaining physical control of your devices at all times. I mean, just making sure that, if you don't have it on you, that it's locked up in a secure place. Using encryption and passwords, and I don't just mean your password of your birth date. I mean your very, very good passwords that are secure. Installing Firewall and remote disabling software. So Firewall, and obviously we're not going to get into the technical details, but firewalls are important to make sure and keep the bad people out, and making sure the environment is only accessed by who is supposed to be accessing it. And then remote disabling, so you lose your phone, and your first call is to figure out how to remotely disable whatever's in there. Really, really important, and a good protection to have. Using adequate security when using public Wi-Fi, and that's really important. Making sure, because it's public Wi-Fi, and I've even gotten to the point where I don't really use public Wi-Fi on my own devices, just because I tend to be so paranoid. And so if you don't need public Wi-Fi, then don't access it. And there are devices out there. One in particular is called a Pineapple that hacksters can use in order to, even when you're doing all you can to protect the information, they can actually get that information if you're using a public Wi-Fi. So I am very paranoid when it comes to this, and a little paranoia I think is a bit good for all of us to make sure that we're keeping this information protected. And then finally, deleting all PHI before discarding any device is really important. Making sure that if you're trashing it, if you're getting rid of it, if you're donating it, making sure that you are wiping all the information so that it is, and you're actually you're successful in the wipe, to make sure that nothing is in there when you discard it or give it away is really, really important. Dumpster cases where information has been found in the dumpster not properly wiped, those happen, and there's fines and penalties for that when that sort of incident is brought to the attention of the people who enforce HIPAA and the state privacy laws. Okay, and so yes, so that handout is a fact sheet. I think they're available, and so please take a look at that. All right, and then just wrapping up, the takeaway for physicians. Know what PHI is. We've talked about that a lot. Make sure you know what PHI breaches are under HIPAA, and make sure you're guarding against them. Knowing that social media posts could violate HIPAA, so just be really careful about them, and make sure your office is really careful about them. And then know how and when to respond to any negative reviews. Again, most importantly, don't respond in anger. And then have a social media response plan for your practice. So I hope this has been helpful. I really appreciate the opportunity from TMLT to kind of go through these issues. If anybody has a question, please feel free to contact me directly. I'm here to help. And if you haven't been told lately, thank you for what you do for patients, then I'm telling you now, thank you for each and every one of you do for patients. So again, thanks, and take care. Have a good day.